All right. Well, my name is John Landy. I'm an emeritus professor at the University of Missouri Law School, and I'm here with Jeff Trueman, who has written a wonderful article that prompted me to have this conversation. So I'm going to start by asking, who the heck are you, Jeff?
I'm trying to figure that out. Um, I live and work in Baltimore, D.C. area. I've been here for more than a couple of decades now. I'm originally from upstate New York, the Syracuse, Utica area, and um, I don't know. I'm trying to get my soul back after all of that litigation stuff. I suppose we all are to some extent, but I've been mediating cases for maybe 15 years or so. I was a lawyer and had my own office here in Southeast Baltimore City for about 10 years. I rode the market up and down. So it was great when it was great, and then it was bad when it was bad. And I'll spare you those details. But one of the adjuncts to my practice was to mediate, and I felt that it was fun, and I felt like finally we can try to work on problems with people um, without having to strategize through the rules of procedure or to be looking over your shoulder. Did I miss a particular case? Am I, one false move and am I going to get sued, or my client's going to lose? I mean, all of that anxiety felt like such a burden that was lifted whenever I had a chance to sit down and just talk to people about what's going on. Maybe you got in a terrible accident. Maybe the real estate deal went bad. Maybe your employment prospect didn't work out. Maybe the contract goal didn't work out. Whatever it is, we can talk about it. So that just kind of kept me curious and motivated to keep working at it. And I remember telling my wife years ago, mediation, that's great to do on the side, but I don't think I can ever make a living doing this. That's a completely different, crazy idea. I don't know what you're talking about. And personally speaking, along the way, the the idea of being married and staying married requires you to be a really good negotiator. And I didn't know that going in. And so when we hit some rocky times, we got some help, and which is the sensible thing to do. And I learned how to listen, learned how to talk in a way that wasn't going to be adversarial and sort of maybe even, dare I say, vulnerable at times, and learned how to just work the relationship and to talk about things that maybe would otherwise have created an argument. Now we can manage. They may be we might have deep disagreements, but we can certainly talk about it. That was happening along the way as I was learning mediation professionally. So it really did become a larger life entity for me personally and professionally. So I come to it now with trying to wrap up an LLM degree at Strauss, and I'm working full time doing what I love to do. I had ran the dispute resolution program for about 6 years here in Baltimore City at the main trial court, the circuit court, and I got to know a lot of people. I was just not one of those administrators that enjoyed sitting behind a desk. So I was in the conference rooms trying to mediate all the time, as much as I possibly could. Not because I had a goal, it was just because that's what I like to do. And as the job became a bit more administrative heavy, I kind of got dissatisfied. And frankly, I was getting calls and requests for my time to spend with people privately. So it just became a time when I felt it was maybe time for me to just take the leap of faith and give it a shot. So I'm now into year 3, and thankfully, so far so good. But it's always the next case. You're just trying to do the best you can in each case and not screw it up. Um, and so part of my studies at school was to have an independent study. And this article that we're talking about was the byproduct, and lots of conversations with Peter Robinson and Stephanie Blondell, and it was just a great, I think, opportunity to reconnect with the network, the people that I've known and worked with either privately or with the court, and to talk about injury cases. I didn't, it wasn't an exclusive group of lawyers that I spoke to, but a lot of the lawyers that I interviewed for this article practice in either wrongful death, medical malpractice, catastrophic injuries. And it's a challenging dynamic if you come at this from a more purist minded mediation approach. It's very difficult to get creative. It's very difficult to work within that competitive litigation culture where your idea that an apology might actually work is met with, that's great, write it on the back of the check. And there are curse words added to that. So it's a challenging dynamic. And I just don't see a lot of people acknowledging that and there's so many injury cases. You know, it's not just Baltimore. You could go to any urban area, probably even big counties, Baltimore County, I'm sure counties outside of Philly and Chicago and et cetera. There are just a God knows how many injury cases where you have this dynamic where we're talking about, it's great when we can talk about things other than the number. I'm all about it and look for every opportunity for that to happen. And I also am a realist. There are plenty of times when there is nothing else to talk about other than the number. And we got to figure out a way to get there with as least damage as we can muster. So
Well,
that's who I am, you know.
okay, well, that gives us a pretty good sense of who you are. As we discussed previously, you are not a social scientist, but you committed social science here.
Yeah, yeah, I'm guilty as charged.
Yeah, committing social science without a license. So I want to ask you a couple of things. First, why did you do the study? And then a couple of things about the scope of the study. So first, tell us why you did the study.
I did this study for two reasons. One was a personal reason to stay in touch with my network and have a substantive conversation with lawyers and adjusters that I've either worked with or would like to work with, to have them tell me what concerns you. You know, the overarching theme is easy to sort of just raise. What are your challenges that you face in the mediation process? What frustrates you and why? So I felt like I could kind of go around the table in that regard. It just felt like that premise was an easy one to work with. So I did it for my own personal reasons, and then I did it just because I'm curious. I think it's good to try to see whether or not the people that I work with have the same frustrations that I would read about in your work and in many others. Plenty of authors that we could tick off who have done the same types, maybe not interviews, but have articulated the same issues. And yes, they're expressed differently, but they are very similar in the sense that, and we'll talk about this, I know, a little bit later on, but they're very similar in the sense that I think they're role identity driven. But we can get into that, but that's what I suspect is going on.
Okay. One of the things I just want to comment is that you are a poster child for the Stone Soup Dispute Resolution Knowledge Project, where you don't need to be a licensed social scientist to go out and interview people and learn things because you're curious, learn things because you've read things that you want to know more about, learn things because you want to connect with people and develop a network. So I applaud you for that. So as a incipient social scientist, I want to talk a little bit about a couple of things in the scope of the study. So you interviewed lawyers, claims adjusters, and mediators, is that right?
Yes.
And tell us about the types and sizes of the cases that you were generally focusing on. And let me preface this by saying, you know, there's a dispute pyramid where all sorts of cases never go to a lawyer, never reach a lawsuit, never go to trial. I'm guessing that, for example, to the extent that there were cases where there was insurance, you know, there are all sorts of cases that insurance adjusters handle with the claimants, never go to a lawyer. Obviously, those are not cases that you mediate by definition. If they go to a lawyer, sometimes they settle without going to mediation. They may just negotiate. So I assume you were dealing with cases obviously that are higher up in the food chain, higher up on the dispute pyramid. Can you tell us about kind of the nature and scope of the kind of cases that you were discussing in the interviews?
Sure. Many of the many of the injury related, I'll just call them personal injury, wrongful death cases, can go anywhere from a 5-figure range on up to a 7 and 8 figure range. And they may be complicated with multiple parties, as you might have with an asbestos case or with a medical malpractice case where there are other entities involved. There may be just a consumer. There were a couple of consumer lawyers who would specialize in car dealership financing or purchases. Excuse me. There was another lawyer that specializes in bedbug cases. Um, you know, right? I mean, and so they they're all very passionate, and I respect their expertise, and yet they have the same frustrations and challenges that a defense lawyer who is representing hospitals and has to deal with risk management committees, etc. They have very similar frustrations. So the case, and I try purposely to mix it up. So I mean, I could have probably gone exclusively injury, death related, but I did talk to some lawyers who were more transactional, who practiced in construction, who practiced more on financial disputes that had to do with more of a contractual nature. And so I tried to include them in the discussion so that other elements besides money that might be valuable to the parties could at least have its place, so to speak, in this discussion, because I'm well aware that there are there's a whole wide world out there other than injury and death. It's just what I happen to see a lot of when I was in the court, and I continue to see a lot of in private practice.
So tell us what you observed. What were some of the main patterns that you found from your interviews?
I can tell you the overarching theme is how critical trust is. And it's just to begin to unpack this is to say that in markets such as mine, it's not massive, but it's big enough such that even in the injury world, there are lawyers who know each other. Some who don't, but those who do have a firm impression as to whether or not they can be trusted. Dare I say, even liked and respected. It's such a competitive game. And I don't want to say game in the sense that I'm diminishing what it means to the clients involved. But you have interests that have established themselves. The plaintiff's bar has its special group. The defense bar has its special group, and they share resources, and they almost provide you know an echo chamber of sorts for practitioners to get the news from the source that they trust. It's not dissimilar from Fox and MSNBC to some extent. But the notion that lawyers who trust each other makes the process go much more smoothly, and there's a lot more transparency. Yes, there's advocacy, and yes, there's positional bargaining, and there's outcome oriented goals for everyone, but the bargaining dynamic is not as long and tedious and frustrating. They get better numbers from each other when they
So,
trust each other.
so let me follow up about trust. From what you could tell, certainly as a mediator, and of course you also have experience of your own as an advocate, what sorts of things either engendered trust or inhibited trust between the advocates and really the risk managers or adjusters, since they were repeat players as well?
Prior dealing is the biggest thing, and that so but I'll say more about other things, but prior dealing is the first thing. Oh, I've dealt with so and so before, and you know what he or she did, and they'll tell you, and then that's why they don't trust them. On the other hand, if they don't really know each other, there's a certain amount of dealings within the case that they're going to extrapolate into the negotiation. So and so is really difficult at the deposition. Or, I'll look in the case history as I'm putting together a new case, to see if there's a lot of discovery back and forth without any motions to compel, that might be a good sign. But as soon as I see motions to compel, I know we're going to have a problem. And usually it's the lawyers doing this about how bad and how deceitful and how I can't trust them, how all of that just starts to avalanche and build on itself. And not only is trust amongst the lawyers crucial to have a process that is effective and meaningful, but you as the mediator have to be able to be trusted. And you have to do it in record time under very difficult circumstances where people are already nervous about what your role is. You're going to tell me what to do. Are you a judge? Are you not a judge? Are you going to play judge? I don't want to have to compromise. You don't know what it's like to lose a spouse, or you don't know what pressure I'm getting from my bosses to keep this number low, low, low because we've got a great liability defense. I mean, all that stuff is out there, and yet here you are helicoptering in, trying to be, the salesperson and develop trust under these circumstances. It's really tough to do. So if you can start the process the earlier you start it, I think the more time you give yourself and the more success maybe you'll have in terms of developing that rapport.
So
But
let me ask,
trust is key all the way around.
so there are two sets of relationships I want to ask you about in terms of developing trust. One is between the lawyers before they even get to the mediation, and then by the mediator. And you said that having a prior relationship really makes a big difference. Obviously, there are a lot of cases where one hasn't had a prior relationship. What sorts of things can lawyers do to, or have you seen lawyers do to build trust where they haven't had a prior relationship? And what can a mediator do to build trust when the mediator doesn't have a strong prior relationship with the parties or the lawyers?
I think it's just you have to come across as the professional who gets the big picture. I see trust breakdown and I see problems develop if one or both lawyers get overly technical and hang on to their role to the degree that they lose the big picture here. I mean, we all know most cases settle, but if you can approach it as an advocate who's confident, but yet willing to talk and willing to listen, and just you don't have to be technical and you know how there's certain personality types that just because of the way they talk, or if they don't look at you the right way, you just feel like they're playing a role, and you never stop thinking about that. It's the same when you see that amongst lawyers. I think the real good problem solvers are the ones who are practically minded. You know, they'll roll up their sleeves and say, okay, here's why what you're suggesting doesn't work, and have a conversation about it. It's not about because we're going to get a jury to agree with what we're saying and you're going to have to go bankrupt in order to pay the judgment. I mean, it's less threatening. It's just to talk about why things don't work, maybe propose something in as an alternative, because it's always great to have a solution instead of just constantly criticizing. People will keep score and realize that eventually you're not bringing anything. You're just shooting everything I say down. So those kinds of just general problem solving approaches can really help to build trust. And you have to be good at managing yourself. That's another thing. I would say that whether you be the mediator or whether you be the advocate, if you're getting frustrated and your buttons are getting pushed for whatever reason, you have to have maybe done the meditation in the morning, do your yoga, whatever it is, so that you're better at focusing on what really matters. If you start to mirror or react in ways that escalate the sidebar conflict, you're not really dealing with the stuff that you have to deal with as the professional that you have that role in this. And it's very challenging. I mean, I can think of examples as the mediator where my buttons were pushed by lawyers who I thought were just crazy. And it's my fault that I didn't keep it together. And so you just chalk it up to a learning circumstance and just try to remember what that feels like And if you start to feel yourself getting there, just say, okay, I recognize this. I have to do something productive with it. And maybe it's taking a break from the conversation. Maybe it's another mode of communicating. I find that emails are really good for me to sit in an uninterrupted way and just craft what matters to me as the, and I do a lot of that as a mediator. I'll send out, and I've done it even last night for a case next week, to just set the stage. I'm creating Dropbox folders for you. Here's what I want you to upload, and here's why. And let's keep the big picture in mind. I just find that people they're not going to really argue with me over an email. Whereas if I were to say it to them, well, but we've got a really good case, and I guess I'll give you the information, but just keep in mind, we've got to have it's like, stop, just stop.
Well, it's interesting. Wanted to ask about these cases where, to a large extent, you referred that many of them are about the numbers. So I assume that there's no emotions involved, right?
Well, there's a lot of emotion involved. It's very tragic in a way,
But the
because
professionals, they're dispassionate, right? They don't have any emotions.
well,
Tell us
the
about the
way
professionals' emotions.
the way they rechannel them into their professional role, and it ends up becoming the head banging process that I think that they really long for. That they feel that when there's blood on the floor, good work has been done. We had to see that blood in order to move. It's funny because all along the way you get the frowns and you get the animation, and then you see the relief on everyone's faces. Their shoulders come down, they're breathing more, they've got a happy hour in front of them because they got a result that relieves them. And the adage is, well, a good settlement when no one's happy. I don't really buy that. Good settlement is when people are relieved. And yeah, they may have been a lot of noise and grinding of teeth along the way, but they're relieved to be done. And
So it sounds like, I'm sorry, go ahead.
no, there's a lot of emotion. There's a lot. It's just channeled into these professional roles that become so oppositional. Like I say, it's as if the problem solving possibilities are out the window, and I'm in the middle, I suppose, being viewed as an arbitrator because they're trying to convince me, even though I keep reminding them that I'll do what I can. But it's advocacy, like 100% the whole way.
So part of what you're saying is, or what you're saying is that they're acting out emotionally as a part of their role. They think that this is what's needed to be effective. Do you think that they're really feeling these emotions, or is this all play acting?
Good question. I think there's some sincerity to it because, I'm saying that because I think plaintiffs' lawyers, really good ones, are empathetic, and I think that they really feel for the situation that their clients are in, and there is a deep distrust in the plaintiffs bar, generally speaking, of insurance companies, right or wrong. And yet, I spend a lot of time working with carriers and their representatives. Um, they're people too. And, if they paid every dollar that's demanded, you wouldn't have insurance. You got to have insurance in this world for all sorts of reasons. Um, there's reason to be skeptical and maybe cynical about the practices on both sides. We can dig up literature during the asbestos crisis about the shenanigans that went on both sides there. And if it happened in asbestos, it happens elsewhere too. So rather than focus on that, I try to just say, well, look, we've got this particular case. You've got that particular adjuster and lawyer in that room, and you've got that particular lawyer in that room. And by the way, I'll say at times, we're going to maybe have these different combinations of conversations such that they're not in separate rooms all the time. Maybe at a point later on, we're going to get together again with or without the parties to get you through that last gap or something along those lines. So I would just reiterate that there is a genuine feeling there's also an awareness that what we're doing has a bit of a poker game feel or a chess game feel to it because it's strategy and you have to deal with what cards you're dealt with. But I think that the emotions are real in the sense that people, they have jobs to perform, they have roles to play, and they mean something to people. I mean, you work really hard to get to be in that position of a successful lawyer, and you know at that point you've really invested a tremendous amount.
Yeah, I guess my impression from what I've learned generally and also from reading your article is that a lot of the lawyers actually have these feelings. They know how the game is played, and yet they get really pissed
Yeah.
at the other side. So they'll say, you know, why aren't they giving me a reasonable offer? And then they don't make a reasonable offer. And some of that may be play acting, but my impression is that a lot of it is real and a lack of self-awareness. Is that your perception as well?
Well, I think that's a good point. I think you raise the piece that's missing, which is the self awareness piece, because I think you and Bernie Mayer and others have articulated this sort of paradox where they talk about, you know, lawyers talk about, I just want meaningful discussion. I want to cut to the chase and get a good number. I'm so frustrated. Well, are you doing things that contribute to your own frustration? You know, by not responding in a way that's meaningful. You know, the more we play dodgeball and trying to respond to positions that you don't really hold, the more time it's going to take, the more frustrating it can be for everybody. And so I think you've articulated the missing part, which is that self awareness piece to say, you know, I need to play the part that I want to get. But, you know, then that's the dance of, well, who's going to do it first? If I do it first and I get burned, then I'm not going to do it again. And I want to see, make sure that you're going to do it before I do it. There's all that stuff.
Yeah, I mean, I guess what I was trying to separate it out is what I was calling the play acting part, what you were talking about, the role, where, and for better or worse, lawyers may think that that's what they need to do. They may need to bang on the table and yell and take all these extreme positions, and in their own minds know that this is play acting and that they're not really feeling it. And on the other hand, the impression I got again from your article and from other things that I've learned is that they actually really, really feel these things. They're really mad. They're really insulted when the other side comes up with I can't believe it. That's an insulting offer. How could they offer so little, or, offer so much or demand so much?
Yes, I would also add to it. You know, I mean, we're all pretty complicated in the sense that when I'm not in their room, I can imagine that when they've got a lot of air in the tank, a lot of room to move, and they're seeing pretty decent numbers in an early stage, they're feeling a bit good about the process. They may not let me know that. They're going to maintain their frustration in front of me. I understand that. But when I'm away, you know, and again, I'd love to know what's going on, be the fly on the wall when I'm not there. But I'm sure that there's some wink and a nod to their client when I leave the room so that the client knows I've got the warrior that I wanted, and that, you know, we'll see how this plays out before we settle. And so far, so good. So there sometimes is a wink and a nod, but there is genuine feelings to it too.
Yeah. Well, let me move on to talk about the three elements that my co-authors and I talk about in the litigation interest and risk assessment structure, which is the expected court outcome, the tangible costs, and the intangible costs. So I'd like you to describe what you have observed from your practice, as well as what you've learned from your interviews, about, if you just kind of describe the process of discussing the expected court outcomes.
I've been thinking a lot about that lately, um, not because I knew to some extent what we might discuss today, but just because that so often I think mediation has become, in this litigated context, synonymous with case evaluation. And we know that neutral evaluation is its own process. Mediation really should be a much larger view on the dynamic between the parties, certainly underlying interests, communication issues. Um, But what happens is that it becomes so narrow, so narrowly focused on predicting outcome to the point where even before mediation, firms will consult with mock juries and have those reports given to me to use in mediation. I find that a bit bizarre in the sense that, well, that's a quasi litigated outcome, and I get that, it might I don't know, be accurate, but I can get there's one example, an extreme example, and I can't give details of where three mock juries were impaneled, giving the defense all the confidence that it felt it needed, and the case did go to trial. I couldn't resolve it in mediation. A retired judge they got didn't resolve it, and I kept going with the emails and phone calls. I think we can get it done at this number. Take that number times three, and that's what, seven figures got whacked. And it's like all your jury stuff, you know, try the same case 10 times, you're not going to get the same result. And
And
that, yeah.
go
So I feel like it's such a disappointment when you're stuck as the mediator to try to then just, deal with that very narrow conversation about whose prediction of the outcome is going to be most likely to, get realized.
I mean, it sounds as if what you're validating is people's observations for a long time is that the discussion is really betting against the trial outcome, and that what the discussion is my prediction of the trial outcome is more accurate than yours, and here's why, and I'd be a fool to settle at the number that you are putting forward because the trial outcome would be so much more favorable to me. And so it sounds as if the vast majority of the discussion is of that kind of issue. Is that right?
A lot of it is, yes. Now it's my job, and I'm not always clear. I have to really think through ahead of time how I'm going to deal with that, because I have to be the one who's broadening the scope. I have to be the one that clears out that clutter to say, yeah, that's one way of looking at the problem. And I hate to sort of divide and conquer, but there's always tension between client and lawyer. So you can start there and try to understand what the client really wants. Now, plenty of times, rightfully so, client will defer to what the lawyer suggests. And I respect that. And so maybe they're walking in tandem and they're in simpatico. That's fine. But I can only do so much if we're going to limit our conversation to that litigated outcome. I'll start to throw out numbers that no one else is talking about. So if I can't find a way out, then I'll play the game, but I'll take advantage of my position as the neutral to throw out numbers that I'm pretty sure both sides would be tempted by, even though they're swearing up and down they would not be tempted by. I
Right. So
just
this
call
is,
them on their bluff.
yeah. I mean, this is what mediators commonly do, where they'll say, I guess with the mediator's proposal, they'll say, this is not a prediction of what would happen at trial. This is just my sense of where a settlement might be possible, as a way to finesse these arguments about what would happen at trial, which seems to be the main focus of the lawyers on both sides. Is that
Right. So I
correct?
mean, yes, and it is a good reminder that we're not talking about what happened to you personally now that you're a quadriplegic. We're talking about the lawsuit. There might be complications in terms of even getting liability across the finish line. So that's one conversation. But to the lawyers, it's to say, look, I'm not telling you what the number is going to be. Nobody can say that. I don't spend a lot of time on that because they know that themselves. But I'll throw out numbers that I think might be within the realm of possibilities to settle the case. And I'll just keep saying that and keep trying to focus us back on that. But John, it's important to point out that these points have to be well timed. You can't just go in there and start with that. You have to let the lawyers go through all of their explanations of litigated prediction, and that's fine. I know it. You've given it to me in written form, And I guess we need to go through it again because you're in front of your adjuster or you're in front of your client. And I get that. I don't want to sound disparaging of that, but it's frustrating sometimes when I know that I'm not there to be persuaded. However, and again, if the parties want to know my opinion, and sometimes they do, then that's one thing. And I'm happy to sort of, couch it in a way that says, look, I worked in a trial court and I would make it my job. I made it a point to go and look at litigated outcomes after settlement conference a month before trial. Case didn't resolve, went to trial. So I kept score and I could keep score in terms of case type, who the lawyers were and all that stuff, and had, a pretty good database of geez, I've heard you say that before, counsel, and if you'll remember this case with so and so, you said the same thing. And so you got to be, and I've done that even in private cases where I've looked it up, where I did the research, and I found an appellate case where the exact same arguments were being made, and it didn't prevail.
Yeah.
So why are you doing it again? And in fact, you are the counsel of record. Well, they decided it wrongly. Oh, okay. They decided it wrong. I hear you. But that's now on the books. So what do you think is going to happen,
Yeah. Well, let me talk about the other two elements in our framework. The next one is the future tangible costs, the additional legal fees and expenses, which might include any further discovery or expert witnesses or other expenses. Obviously, when they're negotiating or mediating, there's potentially sizable legal fees and expenses if they go to trial, which obviously would reduce the net recovery. To what extent, my impression is that this doesn't get factored in very much, except maybe till the end. Is that correct? Or what's your observation from your own experience, and also from what to the extent that you learned from your interviews?
Well, based on my experience, most lawyers will talk about the tangible costs. And the successful firms, it's even on the plaintiff side, they have enough in reserves to fight, the big defense firms and the big carriers, and go and take it through to trial and take it up on appeal and keep going for years and years and years at a time. Whether or not their client wants to do that is another matter, of course. But there are pretty much open conversations about the costs. I mean,
Can I interrupt for a second? There are two different questions I wanted to check with you about. You're talking about whether they can afford to do it. I wanted to really ask about their calculations. So in other words, if they think that they could get $1 million verdict, but it would cost an extra $100,000 to go to trial, their net value, or it'd be worth it to them to settle for $900,000. So the question is how much they're doing that calculation in the process of negotiation and mediation, and at what stage in the process are they factoring those things in? So that's what I kind of wanted to
okay.
hear.
So the factoring in is sort of like running the numbers tends to happen later once we have sort of the end game in sight, because and it makes sense because it's harder to do the math without knowing what your gross number is going to be. So if you have some sense about, what the gross range might be, you might say, okay, well, if we compromise and land at 400, let's say, then we'll run the numbers and we don't have to. Whereas, in a good comparison would be, okay, if you say no to the 4, then you're going to have to net 4 plus for your costs and expenses and everything else in order to get the same result here in settlement. So those kinds of conversations happen later in the process. I know that most of the lawyers that I've worked with will have an honest conversation with their clients about the costs that are going to be incurred, because the experts, I mean, they pay for it ultimately. It comes out of their pocket. So does that answer your question about the tangible costs?
Yeah. So let
Okay.
me shift gears to the intangible costs, which, there's a whole long laundry list, particularly for plaintiffs in terms of stress and anxiety and delay and cost and loss of opportunities. But also there are intangible costs for defendants in terms of risk and having cases open. Um, so to what extent are those things discussed at all in the mediation, again, based on your experience? And I don't know how much you discuss that in your interviews, but those are important in the study that's in the book that my co-authors and I wrote. Those, our perception was that these are things that aren't really considered very much or valued explicitly. And I guess I'm curious to what extent, what your observations have been about this.
There really isn't a lot of discussion or a lot of focus on the intangible costs of, a multi-day or multi-week trial. And there is like never a discussion about how how long-winded this thing could really go in ways that could be unpredictable. It may not be the norm, but every now and again, there's a hotly contested case that all of a sudden is up on appeal now for the second time or the third time. And there's a lead paint case here in Baltimore City that is going back for the fourth remand. And this is after now law has been changed in Maryland. So, both sides are going at it to such a degree that I don't think they realize the consequences to the law that then they have to then deal with. And it could go on either side. I mean, there's been a recent change now for the standard for expert testimony. And it's probably more pro defense now.
Mhm.
Whereas there have been other appeals in lead paint, let's say, that have been pro plaintiff. So I don't know whether anybody is, I mean, I'm sure the lawyers talk about it at some point, but I don't think that there's a lot of conversation about, well, geez, if we continue to appeal this, we you might not be happy with the result long term. I mean, not only that case, I think the client only cares about his or her case, but then there's the longer term prospect of what it means. So, and I'm not even getting into the emotional and the psychological aspects of extended trials. I think generally speaking, lawyers have a lot of confidence that they'll be able to prepare their clients and their witnesses. And a lot of them do. I mean, look at the cases. I mean, it doesn't seem to be on, nobody's afraid, put it that way, of doing a long-winded trial. So they happen, they occur every now and again. It's just, you know, there's not much discussion about the cost of it, especially when they're far apart in mediation. If there's a manageable gap, if it looks like we can get there, then I'll start raising it, usually in caucus, if I haven't raised it before. If I've raised it before, I try not to overdo it because I think we have other ways to get there. But, there's a great summary. I don't know if you know Ben Picker, who
I
is
do.
yeah, he's a terrific, terrific mediator, terrific person in Philadelphia. He has a wonderful one-page summary of what truth means in court. And so this to me is a psychological reality check. I don't know if it's an intangible cost, but it is certainly a psychological reality check about what it means to go into court. You think that it's all about finding the truth. You think it's all about justice. It's about winning. It's about winning. As long as you're not doing anything illegal that anybody finds out about, then all is fair. And so, what you think is what really happened, what they think what really happened, what the judge thinks, none of that matters. What really matters is what complete strangers think happened and how they are going to reconcile wildly different expert accounts of what happened or factual accounts about what happened. I mean, how do people who weren't there, who don't know, how do they figure those things out? Well, geez, that doctor reminds me a bit of my doctor, who I trust. Or, that doctor reminds me of my ex, who I don't trust. I
Yeah,
might not even articulate these things, but I'm feeling them.
yeah. Well, this has been really helpful. I want to kind of wrap up by asking you to um, give any takeaways, any insights for practitioners, for academics, for students, based on particularly, I guess, what you've learned from your interviews, but also from your experience. What sorts of things would make things work well, better? What sorts of activities, insights?
I think there's one word, and it's lead. Be a leader. Lead, go to where you think the real heart of the problem is, as the mediator. I think the more you sort of pretend that a particular a format, or what am I thinking of, is a particular practice orientation, is sort of the answer to all of life's problems. I that doesn't work for me. I know there are some wonderfully respected and effective mediators. Maybe that works for them, but it doesn't work for me. So my response to your question is, if within the hardest charging money dispute there's an interpersonal problem, go there. Maybe have that counselor moment where you take the lawyers, and I've done this, to a separate area, put chairs in a circle, and sit down almost as if it's couples counseling. And in this particular example, it was a male female attorney. It was like brother and sister, terrible cat and dog fight. And it's like, we can resolve this and help both of you guys move on. But apparently, something happened pre mediation that has your ire up. What happened? And we talked about that. And they didn't necessarily come to agreement about what should have happened, but they at least knew what happened. Case resolved. And to this day, the hard charging plaintiff's lawyer talks about me in the marketplace as if I'm that mediator who did what no other would do.
Well, it sounds like I've used the term conflict diagnostician, and that it sounds like what you're describing is that in your context, a mediator should be a conflict diagnostician. In that case, you had that conversation with the two attorneys and helped them figure out what the problem, what the conflict was really about, and by doing so, enabled them to get past it. Is that a good summary?
Yeah, and to add to it, use your judgment. So don't feel that you have to play diagnostician or interpersonal guru in every instance, because that might not really be the issue. Like I said before, sometimes it really is about helping them get to the right number so that they can move on. You know, motor torts, they're everywhere. God knows we can't wait until there's vehicle, driverless cars, so that maybe then the amount of accident claims can come down. But those are great examples. We just have to find a number. We're not talking about a defendant who was drunk. We're not talking about a defendant who was texting. It's just an accident, and it happened. And maybe it's soft tissue, and maybe it's not life altering, but for whatever reason, the carrier is not come up into five figures, and the plaintiff is still hanging out at six figures, and we got to resolve it, and we can. So I'm not going to play guru in those instances. I'm going to help him get to a number. Having said that, if I hear the plaintiff continually say, the bus driver told me to stay down, wouldn't let me get up. I could have gotten up. He told me to stay down. He kept saying this over and over again. It's like, well, what do you mean by that? He took it to mean almost a political thing, that the bus driver wasn't letting him stand up, whereas the driver was following protocol after an accident to make sure everyone was okay and to make sure that the vehicle wasn't going to catch on fire or whatever, trying to maintain some measure of control, and didn't mean it like that at all. Once we were able to get through that problem, we could resolve it.
Yeah, I guess I would describe all of that as encompassed in this concept of a conflict diagnostician. I mean, basically, you're trying to figure out what the heck the impasse is, why there's a dispute, and it may
Right.
be a sincere difference of opinion about what would happen if they went to court. It may be a sincere difference of opinion about a particular issue or particular piece of evidence, but really figuring out what the conflict is about, which the parties and the lawyers may not be aware of.
Yeah, you have to ask why. Just keep asking why, stay curious, and stay open minded, because there are plenty of times that what I thought was at issue really wasn't at issue. And so you just have to be willing to go back to the drawing board.
Well, that's really helpful. This has been a great conversation. I really appreciate your taking the time to talk with me. And of course, I'm recording this with the goal of sharing it, and I hope viewers enjoy it as well. Thanks so much, Jeff.
Thank you.
All right.